Okay, thanks. A very big thank to the organizers of this event. I'm very happy with this. It's a wonderful opportunity to talk about our cultural project, and a big thanks to the speakers I'll be very glad to hear what they have to say about this. I'll be very short. I will just offer a few clues about the project that is behind the series. Now, there are two main concerns behind this series. The first, basically, is a language issue, very basic issue. The other has to do with the specific methodological lesson one can learn from the works that feature in our series. Well, as to the genesis of the book series, in 2014, I had just left London to go to Antwerp as a Marie Curie Fellow, Antwerp, where I met Michael, actually. And while in London, I had the opportunity to talk to a few key legal scholars, such as William Twining, Roger Cotterell, Emmanuel Melissaris, and others. Well, all of them were very interested in knowing what a few key continental authors and also Italian authors specifically did say. Well, a few among the most senior colleagues had the opportunity to read French, that studied French at school and could read authors like François Genis, Maurice Soriot, Léon Duguay, Georges Guénard. But I mean, more and more scholars were less familiar with foreign languages. This is, I mean, the pros and cons of speaking the language of the empire, what Latin and French used to be a few centuries ago. And since Maitland's translation of Gierke's political theories of the Middle Age, there has been little attention to the works of continental authors. I mean, there are translations, but they are limited, they are partial, and scholars, Anglophone scholars, in the UK, in the US, in Australia, cannot really go to the main works of Eugen Ehrlich, Cornelis van Vollenhoven, Santi Romano, Vidar Cesarini Sforza, Costantino Mortadi, all these authors who are, I think, very key to what they are doing today in their respective fields. And this is the language issue mainly, and we wanted to bring this key works to an Anglophone audience. But other than this issue, what really prompted us to envisage the series is a typical trait of these authors. Most of them, at least, have an idea, they share the idea that law and politics, and so the study of both, cannot be disentangled. So there is no purely legal, no purely political phenomenon. This gets reflected in the very first lines of the series presentation on the Routledge webpage. Quote, a core legacy of the continental juridico-political tradition is the methodological commitment to the idea that law and politics are inextricably tied to one another. On the one hand, law is to be studied in the light of the concrete political dynamics, social forces, and societal movements that make law what it is. On the other hand, the analysis of political processes should be coupled with the study of the legal techniques through which politics exerts its effects on social reality, unquote. So the juridico-political is the hallmark of this cultural project. It doesn't merely bring forgotten authors to an Anglophone audience, but revives an approach that most legal philosophers, especially analytic jurisprudence, and most political philosophers, especially in normative political theory, are still unfamiliar with. The idea is that politics expresses itself through the legal language, and that all legal phenomena are political in nature. The example, one of the most glaring example, one of the most forgotten example is that of legal pluralism. How legal pluralism, although there is a broad and vital field today, and especially in legal sociology, in legal anthropology, but still not in legal philosophy, legal and political philosophy, political theory, and so on. The example of legal pluralism is indicative of this entanglement. And this is why it was so important to translate, at least in my view, Santi Romano's The Legal Order. It is just an example of how the definition of something as a law, and hence the definition of something as non-law, was key to the political project of the modern state. Legal meaning itself is a political battlefield. Now, this is just one of the examples of how the series wants to draw attention to older and more contemporary works that want to revive this idea, want to emphasize this idea. I mean, not everybody has to agree on this, but the thing is this is an issue that has long been forgotten and deserves new attention. One should only think how Hans Kelsen, for example, has been studied as if it were Janus faced the political Kelsen and the legal Kelsen. Now, Lars's book, Hans Kelsen's Pure Theory, although settled the score with this unduly separation, but I think this is a lesson that most methodologists in legal and political studies still have to learn. Now, this just wanted to give you a few clues about the reasons why we wanted to create this series. And the series, I think, now is featuring a few important works by contemporary and non-contemporary authors. Now I give the floor to Marco, and I will be happy to answer your questions if there are.
So I'm going to say a few words just on the authors that we have published and on the future plans actually for publications. It has not always been easy to retrieve copyrights or having access in general, not to the right to reprint or to translate, as it has been the case for what I think are the most important contributions of the series. But we managed to get both Romano's and Betti's copyrights, and as you know, Mariano translated The Legal Order, which probably has been the most visible of the books translated until now in the series, and now it is forthcoming a new translation of Betti with an introduction by Lars. Now, I want to make clear that our intention has been since the beginning, of course, to somehow introduce into the Anglo-Saxon world a certain type of, I would say, Italian tradition, but not limited actually to the Italian tradition. This is why the series is entitled to Continental Perspectives. The general sense, I'm repeating a bit what Mariano was saying before, but I want to insist on that, is that there has been at a certain point, which is probably dateable to the end of the previous century, a cleavage has emerged, and you can actually verify it from just looking at the bibliography of almost all the major books published in the US, in North America, and in the UK or in the Commonwealth. There used to be, if you check old books, there used to be a lot of references actually to monographs or edited collections published in French, in German, a bit less, but still somehow you would find certain references to books written in Spanish or in Italian. Now you read the major works published by legal scholars in the Commonwealth or in North America, and you realize very quickly that they have had access only to works published in English. Now, as Mariano was saying, this is at one level, is one of the perks of a certain way of globalizing scholarship. But of course, on the other hand, it has basically excluded from the reach of those scholars a certain amount of precious intellectual resources. And this is why the idea is to try to introduce both past and contemporary authors into that debate. So I would say that the main target of the series is actually to speak, to talk and to make available, therefore, to a certain audience, works that we think are actually either classics or they are potentially relevant in order to do both legal comparative works and legal theoretical work in that tradition, which we call broadly the continental tradition. It is for this reason, therefore, that we also are trying now to obtain the rights and to translate, if the Spanish Minister of Culture will be generous enough to support the translation, a collection of essays by García Pelayo, in particular on his work on comparative constitutional law, which will be edited by Agustin Menendez. And I'm currently translating, which is actually an excruciating task, I'm currently translating the Constitution in the material sense, which is really, really a difficult enterprise, I must say, in particular for the way Mortati wrote the book. But of course, we are also open, as you can see from the authors that we have published, also to the publication of other works which somehow uses or make reference or try to update that particular type of tradition. I mean, I think it's quite visible that I would say that the core of the tradition is a certain type of legal institutionalism, and hence also why so much interest in both a certain version of pluralism, of the way pluralism makes its way into comparative and theoretical studies on the one hand, and on the other hand, on the link, as Mariano was saying, between the political and the legal system. Now, it is quite interesting, in my view, to see that there is a sense in which, at least in comparative constitutional law, some scholars, it's difficult to quantify it, are actually trying to retrieve or to tap into the resources offered by that tradition. I mean, just to mention a couple of works that have been published recently, which are not published on our series, but they have just been released. One by Joel Colon Rios, which contains actually almost a whole chapter on Mortati's work, and one by Luciano Pinelli on the history of the concept of constituent power, which again engages with some of the authors that either we have translated or that we plan to translate for our series. So the idea is fundamentally, to sum it up, and then to leave it open to the debate and to the other intervention of the other speakers, is fundamentally to offer, to make accessible a certain type of intellectual resources that we thought were clearly missing in the Anglo-Saxon world. And this is why I insist that the target is fundamentally the debate that is either organized in Anglo-Saxon circles, or it is basically run in English. Because obviously, as we know, in other languages, I'm thinking, for example, South America, some of the authors we make reference to or we are translating are actually very well known and properly studied. And I think I will close it here.
Thanks indeed to Mariano and Marco. Brilliant. I think this is a really great project. We do recommend this book series, and if you are curious, you can also find a book review of the translation of the legal order by Santi Romano in the latest issue of the European Journal of International Law. The book review was written by Filippo Fontanelli, one of the editors, among other things, of the Sant'Anna Legal Studies project. Having said that, thanks indeed, and I will give the floor to Lars VINX. Lars, ready where you are. You have 15 minutes. Thanks indeed.
One of the books that have or that are soon to appear in this book series that we are talking about, and that is the English translation of Betty's book on hermeneutics as a general theory of the sciences of the spirit. So there's an interesting fact about this book, which is that it appears not to have been translated originally in Italian, but in German. And Betty was very influenced, of course, by a German tradition of hermeneutical thought, in particular by the Romantic hermeneutics of the 19th century and of authors like Schleiermacher. And what he's trying to set out to do in his book is to show that there is a method or a technique of hermeneutics that can turn the sciences of the spirit, or the Geisteswissenschaften, as they would be called in German, into truly objective sciences that can achieve adequate understanding of historical sources. And of course, an interesting aspect of this book is that Betty engages in a debate, or a critical debate, a polemic with Hans-Georg Gadamer's hermeneutics, which of course is the most well-known philosophical hermeneutics of the 20th century. And if one looks at this debate, one sees that there's a strange reversal of roles here between, on the one hand, Gadamer, the philosopher, and on the other hand, Betty, the jurist, because ironically, it is Gadamer, the philosopher, who thinks that juristic hermeneutics, or legal hermeneutics, is a general paradigm for hermeneutics, and that all hermeneutics should be understood along the lines of legal hermeneutics, whereas it's the jurist, Betty, who takes the opposing position and thinks that general hermeneutics has to be distinguished from juristic hermeneutics, and who treats juristic hermeneutics as a special case, and perhaps in some ways, from the point of view of a general theory of hermeneutics, as a subordinate case. And I think that the debate that has spun out between the two is very interesting and still relevant. And so what I'm going to try to argue in a few minutes is that perhaps authors who are not capable of reading German or Italian texts would do well, if they're interested in problems of hermeneutics and juristic hermeneutics in particular, to take note of this volume. So Betty in the volume presents a number of hermeneutical canons, as I'm sure you're aware. So these are rules of proper interpretation that are supposed to secure the objectivity of understanding. So there is a canon of hermeneutical autonomy, which advises an interpreter to respect the original meaning of the source. There's a canon of totality, which requires an act of understanding to be embedded in the totality of the life of the person who brought forth the text or the utterance that we are trying to interpret. There's a canon of actuality that forces us to try to relate what we see in the source to our own experiences in order to understand the source more deeply. And there's also a canon of adequacy of meaning that roughly demands that we do not impose our own preconceptions, our own ideals onto the source, but let it speak for itself. And the idea is that if these canons are appropriately followed, then it's possible to have hermeneutics as a science that achieves objectively adequate understanding of the meaning that some historical person, the producer of some source, wanted to express. Now, of course, this model set out in these canons does not quite fit with juristic hermeneutics, it seems. So in juristic hermeneutics, the need for application, or the canon of actuality, pushes aside or strains against some of the other canons that Betty proposes, in particular the canons of autonomy and adequacy. So, of course, when we interpret laws, we assume that the result of the interpretation is going to tell us something about obligations that people have that perhaps are enforceable against them. And in interpreting laws, as a result, we strain to interpret laws as reasonable and to make the demands of the law come out to be justifiable. And perhaps in some cases, this will require legal interpretation to depart from what the intentions of the legislator might have been, the actual intentions, that is. So juristic hermeneutics, to put it in Dworkinian terms, is to portray the law in an acceptable or perhaps a morally attractive light. It's not concerned to just elucidate the original intentions or the original meaning of an utterance as it was undertaken by a legislator. And so Betty is quite clear that, well, in this respect, juristic hermeneutics is not scientific, and it's a special case of hermeneutics that is to be distinguished from the general science of hermeneutics. But Gadamer, of course, takes exactly, as I said already, the opposite tack. So he thinks that what happens in juristic interpretation happens in all interpretation. So as you are aware, of course, Gadamer thinks that in order to understand the text, we must work with what he calls an anticipation of truth or perfection in our understanding of the source. We must assume that what the tradition wants to tell us, what it wants to communicate, is true, or perhaps even in some cases morally binding if we are confronted with a practical source. So just as a juristic interpreter must presume that the claims of law are reasonable, apparently, so according to Gadamer, a historical interpreter, or someone who wants to understand whatever anyone else has said, must assume that the claims that are made by the historical tradition are by and large accurate. And this anticipation of perfection corresponds to the juristic assumption that the laws enacted by a sovereign are to be seen as reasonable. And now Gadamer, of course, gives a specific twist to this idea. He claims that there are no tradition-independent standards of practical judgment. So understanding is always realized through hermeneutic encounters with a tradition that's held to be authoritative. And so understanding must engage the tradition's claims to authority, must take them seriously, perhaps in some cases defer to them, and a fully non-evaluative or objective, normatively disengaged form of understanding is seen to be impossible. And so Betti, of course, is set against this view because he thinks that it undermines the idea of a science, an objective science of understanding or hermeneutics. But it seems that on some level, Betti's arguments are not very compelling against Gadamer. So really what he claims is basically that if Gadamer was right, then a science of hermeneutics, a science of the spirit would be impossible. But of course, in a sense, that is precisely what Gadamer claims. So it seems that the objection doesn't really come to very much. One might even argue perhaps that Betti's hermeneutics is working with a theory of meaning that in modern philosophy of language has come under pretty heavy fire. So Betti assumes that it must be possible to achieve objectively adequate understanding because the meaning of the sources, the expressions, the utterances that we want to interpret is determined by the intentions of the speaker or the writer or the producer of some linguistic item. And in modern philosophy of language, this expressivist view of meaning has come to be largely rejected. But still, on working through Betti's little treatise, in the end, I came away with the impression that his view, despite perhaps its somewhat shaky philosophical foundations, is much more compelling or more convincing than Gadamer lets on. So let me just close with a brief suggestion as to why that might be the case. So Gadamer claims that as interpreters, we have to submit or we have to defer to the claims of tradition in order to enable understanding. So some philosophers of language like Donald Davidson have argued that in order to understand anyone, we have to apply a principle of charity. We wouldn't be able to interpret what people say to understand it unless we assume that what they say is true. And disagreement, misunderstanding becomes possible only on the basis of the application of this principle of charity. And that is a claim that Gadamer himself seems to endorse in his hermeneutics. But what someone who wanted to defend Betti might respond at this point, I take it, is that once disagreement does become possible and once it is meaningful, this indicates that the principle of charity has already been successfully applied, and that as a result, the appeal to the need to hold what the tradition says to be true can no longer be invoked to paper over the disagreement. And it seems at that point, Gadamer's view that we ought to defer to a tradition is quite problematic. And Betti's hermeneutics here, I think, offers a practically more adequate picture of how we might encounter disagreement with traditions in which we stand at that point. And so I think that it would be a very interesting, a very useful project to try to see if Betti's general intuitions about how interpretation ought to work could be rephrased or reformulated in perhaps a different methodological background than Betty himself relies on, and thus be made quite compelling. And it seems to me to do that might make an important contribution to contemporary debates as they are had by Anglo-American legal philosophers about the nature of legal interpretation. So I'm very, very glad and very happy that this book has been made available, because I think it could shed an interesting light, given that the international audience can now read it on contemporary debates on interpretation. Thank you very much.
Thanks indeed, Lars. It was very interesting, and we are also very glad that Betty's works, will be available soon in English as well. So thanks for your effort. And after this focus on the book series, we can zoom out a bit, and in order to discuss the Italian tradition, if any, or Italian legacy in broader terms. And we can do that with two outstanding scholars, Giovanni Marini and Cesare Pinelli. I'm very happy that they accepted our invitation, and then I would like to thank Giorgio De Petto for facilitating the contact. Of course, this webinar has been the outcome of a joint effort, but Giorgio really played a special role. So I will give the floor to Giovanni Marini first. Giovanni, ready where you are. You have 15 minutes. Thank you very much.
Can you hear?
Yeah, okay. Very well.
Thank you very much for the invitation, and thank you very much for inviting me to share this interesting project, which is really outstanding and interesting. Because I think, let me spend first a few words about the project, which is really interesting. And I think that it fits perfectly in the new trends in comparative law, in which the focus is shifting from the old and classic similarities and difference talk to a new approach in which the focus is on the transnational diffusion of legal thought. So the idea that legal thought is always a problem, a process of globalization, in which there are a few and different waves which are very well spread all over the world. And I think that's the idea is very important. I think that it's important to focus, as far as comparative law, on some features which are a little bit shared by all the new trends. So I would say I have a few points that I would like to put forward. And the first is that at the transnational order, national diversity is only a different solution within a common conceptual structure and within a common language. So specific regimes are extremely different in details, but they fit always into a relatively small number of patterns reproduced country after country. And I think that the project is very interesting in this perspective. Second point, it's in the new trends are highlighted the idea that the systems are in a complex relations of interaction and integration. So national or regional system can be in relation of relative openness or closedness vis-a-vis other similar system of comparable scale. So the difference and similarities are really relatives, and they depend on the influence of different way of legal thoughts. The third point is that there is a diffusion from center and periphery, so-called peripheries. and we might distinguish between center and context of production, where legal thought is developed and flourish, and contexts of reception, so peripheries. And the process of transfer is very much more complex than the transplant ideas usually highlight. So the important system appraises the model and always transforms the model, even in radical ways, by a creative and original reshaping of the transplanted element in the receiving context. So, and this is another important point which deserves to be studied at this high level. Let me first come back to the second point that must be highlighted in this perspective. And I think that it's very important, the Italian legacy. So I went through an old book. So by now it's pretty old, and it's the book in which Vittorio Denti, that, as you know, was an important comparative lawyer, gives a sketch of the Italian framework of the Italian comparative lawyers. Of the Italian comparative lawyers. And Dentis, in the 79, distinguished three different approaches which must be, in a way, developed, and that are really developed by the more outstanding Italian comparative lawyers. And he sees three different approaches, which, according to Denti, must be taken together. And this is the policy approach, the functional approach, the historical approach, and the structural approach. And all the three approaches have some interesting features, some champion. And for the functional approach, Denti quotes Cappelletti. For the historical approach, as you know, Denti quotes Gino Gorla. And for the structural approach, quotes Rodolfo Sacco. I think that this is the legacy. And I think that this is very important, that we develop some of those features, which are still it's a lot of work to be done. And I think that at the international level, those masters have to be reorganized, and many of those things have to be studied with close attention. So I would say, let me focus two different paths along which we can work, and we can develop this Italian legacy. I think one is the first is the renewed focus on tradition. So tracing back the roots is a work of representation, and its process for construction and reconstruction gradually occupies a central place in comparative studies. And I think that Gino Gorla's approach is very important, and an investigation into legal tradition may better be understood as a self-reflection and a critical interrogation of the various and conflicting political projects underlying comparative law. The second point is the legacy of the functional analysis. So what Cappelletti wanted to do is just to focus on promising institutions and promising solutions. For what? What for? Because Cappelletti wanted to fight the marginality. And so he wanted to give more power to the people who lived at the margins in the society. And we have a lot of interesting issues which could be still approached in this light. And I have in mind the emergence even in comparative law, but in civil law, the emergence of distributive analysis. So I think that if you want to understand the power relations, you have to analyze the institutional structure that governs the transactions and economic relations. And you have to focus on the way in which the legal rules give powers and possibilities to the private parties. So on this perspective, we have still a lot of work to do. Thank you very much.
Thanks indeed, Giovanni. You touched upon a number of impressive and very important issues that you also recalled Cappelletti, Gorla, so really some giants of the Italian tradition. So thanks indeed. I'm sure that this will trigger an interesting series of questions afterwards. And now I give the floor to Cesare Pinelli. Thanks indeed for being with us. I give you the floor.
Thanks to you, Giuseppe. I'm very also happy to stay here with you to speak about this topic. Now, I will pose and attempt to answer two questions. The first is, where are we for what concerns the Italian legacy, especially with respect to very well-known authors but they were very well-known authors in Italy, but till now they are not. Let us quote Santi Romano, whose famous book has been translated only recently in English by Mariano CROCE, and Costantino Mortati, whose seminal book on La Costituzione in senso materiale is going to be translated in English by Marco Goldoni, as I've heard. Now, so where are we? We are at this, with respect to these authors, which have marked really the tradition, especially of public law and constitutional law in Italy. We are in a situation with respect to exchanges with especially with the English Anglo-American tradition in general. We are very back in the sense that it is a sort of one-sided situation. We are, I think, sufficiently aware of what is going on in other countries, while in these countries, awareness of what is going on, or what was going on, what really deserves attention for what concerns the tradition in Italy, well, this is not true. This doesn't. There isn't sufficient awareness of the Italian tradition. To ask ourselves why, and to answer simply that our language, it is difficult to translate our language or things like that. Well, this is clearly an insufficient answer. I think there are many important reasons why in some countries have been, as Giovanni said before, the province, and of course not only Italy but also Spain. But it is interesting also the particular situation of France at this respect. And I mean, in the continental tradition, there are many differences also within the continental tradition. But I think that the most important thing is not where are we, but whether there is an Italian legacy. this is a very engaging question. I don't think I will be able to answer correctly to such a question. I just will give you an insight on on my experience regarding one of the key questions that we are experimenting now in the world of transnational legal theory. I mean, in particular, the rise, which is not recent, and which has been also criticized, but I believe is still alive, of the constitutional pluralism theory, which was firstly diffused by Neil McCormick, but especially and further expanded by Neil Walker. Now, looking at his seminal essays, one from our tradition, of course, is caught by the sense that it is as if constitutional pluralism was born with the EU and globalization and things like that. While we all know that for us, pluralism, although it would be quite problematic to say constitutional pluralism, but say legal pluralism, for us it is obvious to remind that already Santi Romano was aware of the fact and theorized the fact that the law doesn't come only from the state. There are other legal orders that can insist on the same territory of the state, and they compete one with each other, although, of course, a century ago, he thought that the real center of the stage was always the state. So there is no reference to these authors, not only Santi Romano, but also other authors in the very important works of Neil Walker. So this lack of historical background, and I wrote this in a work in honor of Andras Chaillot. I think this deserves attention also because there are other authors who think, as Martin Laughlin, that the constitutional pluralism is must be at least corrected, and he insists very strongly, Laughlin, on the importance of maintaining in this moment a center which can be only given by the state and its law and its constitution, especially. Now, in this, these differences between these UK constitutional scholars, it is important, very important, to stress that the pluralist tradition is far longer than both think. But in the meanwhile, it is important also to stress that one thing is to underline that in legal positivism, there is also a trend like that of Santi Romano in the sense of pluralism, because Santi Romano was also a positivist, while pluralism in the sense that we intend now in the constitutional environment in which we are, not only in Italy, of course, but in all the countries of which we are speaking of, well, in this new environment, there is a normative evaluation of pluralism, which should guide ourselves in the perception of the differences between different kind of pluralism. So I think that since the Italian tradition is rich also of normative approaches to pluralism, I think that this could be an interesting field. Another interesting field could be that of approaching the issue not simply as meaning that there is an Italian contribution to transnational legal theory, but to underline the fact that some author thought contextually with others in the same moment, let us say, in other parts of Europe, theories, elaborated theories, which look partly similar. I can just, I think, for example, but although this is just something I think should be much more elaborated than I'm saying now. For example, Mortati writes contextually with Leibolds in Germany, and there are similarities between Mortati and Leibolds, and also Posada in Spain. There are others, maybe in France. So the crisis of the legal positivism that was brought by Mortati is a completely different thing from the recognition by Romano that there is not only the state, but there are other legal orders that can be considered as such. It is no case, and I will conclude my remarks with this quotation. I don't quote exactly the page, but I am sure of what I'm going to say, that when the Costituzione in senso materiale was published in 1940, 6 years ago, 6 years after Santi Romano published his last very important book, Principi di diritto costituzionale generale, where he reproached very much Mortati for this book, because in this book he caught that something was changing radically, because he saw for the first time that Mortati was speaking about the ends of the public power, of the values that the public power could carry on, contrary to the tradition of the positivistic state, of the positivistic law of his time, which he defended until his death. So I think this is quite important to look also at the differences within the Italian tradition, but also to highlight, I think this is a work that must be done, the analogies between different authors who write contextually on, especially on constitutional theory, between the 40s and the 50s of the past century. Thank you very much.
Indeed, for your thoughts, and thanks for stressing how rich and pluralistic, in a way, I mean, the Italian tradition has been. So we have now, the Q&A session for the audience. If you want to raise questions, please use the chat. You can write your question from Facebook or YouTube if you are watching us there. And we already have a question, actually. I think that our speakers can also see in the private chat the question, but I'm happy to act as a bridge and to read the first one. And in the meantime, I'm sure that many other questions will come. So the first one is a question made by asked by Silvia Filippi. Thank you for your presentations and congratulations for the very interesting book series on continental perspectives. Recently, we have witnessed a growing interest in Italian legal philosophy and legal theory, but in Le Mani su Machiavelli, Portinaro criticizes the Italian theory. Firstly, pointing at the attempt of putting on the same line Machiavelli and Gramsci, operatism and biopolitics, and on the other hand, he thinks the legacy of the so-called masters of democratic disenchantment, as Salvini, Bobbio, and Sartori, among others, should be an alternative to the IT. What do you think about these debates? So this is a very long and a very rich question, which also refers to Portinaro and to other authors who might appear as less relevant, but actually they are, because indeed I know that also Giovanni Marini wrote some very important pieces on Gramsci and on his influence over the way in which we perceive the law. Apart from this question, I would ask Mariano and Marco to, reflect on the many points raised by our discussants, Lars, Giovanni, and Cesare. So perhaps I can give the floor to Mariano first, and then we will also, we will listen to Marco. So Mariano first, thank you.
First of all, I want to thank the speakers, these outstanding scholars who were so kind to share their reflections on the many possible lines within this very broad project, and they very nicely emphasize the many nuances, the many possibilities that have to be actualized within the scope of this project. And something that has to be, something that I'd like to comment a bit is Professor Pinelli's reflections on, the frictions, that is true, the frictions within the Italian tradition. And I think it is very important. I think he said something very, very crucial to the renewed understanding of pluralism. Because it is true what he was saying, the pluralism is a contested concept. And today it is coming at the forefront of many debates in various disciplines. And it is one thing, maybe I should also be cautious when I use pluralism, because probably it is one thing to speak of pluralism within the field of political theory, to which I belong as a political theorist, and pluralism in constitutional theory, which takes a slightly different meaning. And it is true that pluralism itself might be an empty signifier. In this sense, when you apply this concepts within different theoretical environments, this concept changes constitutively. And you take Romano, you take Mortati, you have two entirely different approaches to pluralism, and perhaps solutions to oppose solutions to views of how pluralism should be dealt with within constitutional regimes. At the same time, it is, and Cesare emphasized this, it is a tradition which shows, exhibits clear signs of being a tradition. I think one of the most interesting things to do, and let me say this, because this is also very interesting. There is a parallel project into Italian, which we are running with the publisher Quadlibet, which is trying to do more or less the same. Of course, it is something different because we are republishing not only Italian books, but republishing Italian books who have been forgotten. Not necessarily Santi Romano, who is still very present in many debates, but other authors, or make sure that these authors are read by scholars in other disciplines. So we are doing more or less the same thing. We have more or less the same project with Quadlibet, and Cesare is helping us a lot. Now is editing a new translation, the first translation of a few key essays by Maurice Oriou, and something that I'm very interested in, either in the English project or in the Italian project, is to play off of the frictions within this tradition, the Italian tradition. And as far as my interest is concerned, especially within the institutional tradition, which is a very broad family, and a family which is undercut by many differences, by many disagreements. So this is a rich seam to mine, for sure, something that has to be handled with care in order not to homogenize this. And I agree, and I'm about to finish, I agree with Cesare's remarks on Laughlin's works, Laughlin's writings on pluralism, and the way he uses Schmidt and Romano as though they were trying to more or less sort of reach the same kind of objectives, which is not the case. But maybe this is something we should press on. That is to shine a new light on this tradition, which is not homogeneous, of course, to try and see how the frictions between these giants were particularly sharp at the time. Again, I think that the contrast, the juxtaposition between Romano's thinking and Mortati's thinking is particularly interesting. Also Betti, I mean, very different authors, three authors more or less compromised with the fascist regime. But these frictions, once we have, let's put it like this, once we have contextualized this history, which we are very familiar with, so as far as the Anglophone audience is concerned, we have to contextualize the story. Once the history is contextualized, it would be worth, I think, casting light on the frictions, on the disagreements, because there is something that if there is a limit in the Anglophone reception of disorders, is the tendency to see them as more or less aligned, which is not the case. And the same applies to the way they wanted to use the concept of pluralism. Oriou and Romano had very different concepts of pluralism. So I think there is a lot of work to do. And once we have more or less offered a very, I mean, a broad, as far as it is possible in practice, because it is very difficult to try and find people who are willing to translate books and when publishers willing to give the translation rights. This is a pragmatic difficulty that has to be taken into consideration. As long as it is possible in practice to give a more or less broad sketch of this tradition, I think we can also, with contemporary works by contemporary authors, we can excavate, we can dig out what was at stake in the debates between them. Thank you.
Shall I come in? So if I may add to what Mariano was saying, I will just address very quickly a couple of observations made by Giovanni Marini and Cesare Pinelli, and also I will mention something that is definitely relevant also for LARS VINX scholarship. There is a sense in which it is not very easy to communicate the richness and the nuances, no, of these classics. The point is not much really to convey a homogeneous tradition or legacy to Anglo-Saxon readers. This would be, by the way, impossible fundamentally. But it's way more pragmatic than that. Is that there is a wealth of really still extremely relevant and insightful classics that are almost completely unknown by basically half of the Western legal scholarship. So it is as pragmatic as that at a certain level, no? And under this aspect, I fully share what Cesare Pinelli was saying before, no? That some of these authors are actually part of a sort of a zeitgeist. They all share, let me put it like this, a Weltanschauung that obviously is interpreted with certain localized differences. Posada in a certain way in Spain, Heller, Schment, and Leibold in Germany, Mortati in Italy, but they are clearly part of a certain type of social context, which actually, at one level, it is also, you find certain echoes of at least the same horizon, or the same problematic horizon, even in the UK, on the work of the so-called political pluralists. So the reason why Loughlin was, I would say, vaguely interested in authors like the Italian institutionalist is because I think he immediately thought that they resonated somehow with the work of Lasky, for example, and the school that then Lasky generated, both at the politics department and the law school at the London School of Economics. It is much more difficult, unfortunately, although I fully share what Marini was saying, to actually being able to I would say, contaminate or enrich the Anglo-Saxon debate on comparative, both private law and constitutional law, with the nuance of the Italian school. I mean, the Italian comparative schools actually are so rich, but also at the same time are so differentiated, and they are most of the times embedded in a kind of vernacular language that I must say, at least as a personal experience as a translator from Italian into English, it is really extremely complicated to convey those nuances and the intricacies of the differences between these different approaches. So last but not least, and this is where I want to conclude and to wrap it up, the main risk when the periphery tries to convey certain things and try to basically offer a kind of a Trojan horse to the center is that the center at best will receive it by looking at those gifts with pre-constituted lenses. And a massive problem that we encounter when we actually started working on this was that, at least for what concerns legal thought, political thought is slightly different, but legal thought, in the Anglo-Saxon scholarship, there's a tendency to reduce almost any type of recovery of certain classics to two dichotomies. The most ancient ones is Kelsen versus Schmidt, which has still some traction, and the most recent one, which is Dworkin versus Hart, which also shows that the main coordinates of Anglo-Saxon analytical philosophy have become way more narrower, and that makes it extremely difficult and at times almost impenetrable, to engage in a debate when the coordinates are already basically fixed around these. I would call them basically placeholders rather than tradition.
Awesome. Thanks indeed to Mariano and Marco. I would suggest we could have a super quick, a second round of interventions if Lars, Giovanni, and Cesare want to add something. Lars?
Well, perhaps I have a question to some of the other participants. So, I'm teaching in England, as you have heard, but I'm originally from Germany, and I must confess, my own familiarity with the Italian tradition is perhaps not as deep as it should be, which is, of course, one of the reasons why I very much appreciate the project to publish more of these texts. But I guess one question that I'd be interested in is, so what people think of the connections between the German tradition, or perhaps German language tradition, I should say, and the Italian tradition, because it seems that there's quite a bit of interaction looking at some of the key Italian authors that we have mentioned today, such as Mortati or Santi Romano and Betti, and German language scholarship. So is that perhaps a unified tradition in some sense, as opposed to a mere Italian tradition? Is there something like a continental tradition?
I'm curious to know, if Cesare and Giovanni will address, this very good question posed by Lars, or if they also want to say something on the question asked by Silvia. Giovanni first, and then Cesare. Giovanni, please.
Well, very interesting questions and very interesting problems, and they really deserve a very thorough, very long answers, but I'm trying to be very short. So I would say that trying to answer to Silvia, but I'm not the idea in which I was interested in Gramsci is because Gramsci is not only an important character of the Italian tradition, but it's still more important as far as law is a field in which hegemonic and counter-hegemonic projects can take place. So that's important. The Italian legacy and Italian style, all those things, in my approach, are associated with the idea of hybridity, which is a common thread in all national and transnational traditions. So I think that we should leave the idea that there are sheer and uncontaminated national tradition. Even France, even Germany, which are the pillars on which we build our comparative law projects, are very hybrid. And if you think of some authors like Pleniol or Capitan, they translated the German concepts in French. And I think also that now it's very important, the American impact. But there is more than Americanization. There is a two-way cultural traffic. So the idea of Italy is a semi-periphery. So it's, and the Cappelletti example is very important, because Cappelletti was not only an importer, but was also in the same time an exporter, was a kind of intellectual entrepreneur, And the idea of class action is a nice example of the work, of the way in which the semi-periphery works. So Cappelletti brought class action from United States, reworked according to the continental intellectual framework and exported to Brazil. And then to Brazil, class action became an example and was imitated by continental and by Latin countries. So what is interesting in comparative law is just not to go at the roots and to try to convey the meaning of the authors, but try to understand how the legal consciousness. So there are periods in which we all share common conceptual vocabulary, potential resolutions, typical arguments pro and cons, organizational conceptual schemes. So it's important to understand where they come from, who devises, and what for they are used.
Thank you very much. Cesare, thank you.
Now, I will first answer to Silvia's question, because I think that one has to distinguish between the Italian tradition as was articulated by philosophers. This is very different from the Italian tradition which we are speaking about. So the reaction of Portinaro against the attempt of many philosophers, many of which Italian, to put their hands on Machiavelli, this is a very interesting question, but it's little to do with what we are saying, frankly. It is very different, because the Italian philosophical tradition has had other paths, and so it is difficult to say even if we can say that the authors of the democratic disenchantment as Salvemini, Bobbio, Sartori might counteract the attempts of building an Italian tradition in the sense criticized by Portinaro. It's quite difficult to say. I would also like to add something. First, I think that we would need not 2 hours, but 2 days just to attempt to, not to exhaust, but just to find a common code about what we are saying, because it's very intriguing what we are saying, but I think we need to speak a lot about these things. As for last question, I'm sure that Alessandra will give you an answer, because Alessandra is far better equipped than I am for what concerns the German. The relationship between a German and Italian tradition. I would just like to add something about what lastly said Marco about the debate, the seminal debate between Dworkin and Hart, following that between Kelsen and Schmidt. In that case, I think we Italian have some assay really in the world legal exchanges, which is due to a different kind of exchange between Italian legal philosophers and lawyers. Legal philosophers and legal philosophers of the rest of the world. So let's say the importance of Bobbio, especially, should be underlined. I'm just reading now a very important book of Massimo Latorre, who follows all these paths, and it's very, very interesting. Also, what he says about the relationship between the Italian and all these different authors as Dworkin and Hart, etc. So, but this is a further field. We are speaking about the comparative field and transnational legal theory in general. I'm afraid I must stop now. Thank you.
Thanks indeed. And as you said, I mean, there is food for other 2 or 3 seminars, and hopefully this event will trigger indeed many other initiatives. As also Cesare said, I mean, we now give the floor to Alessandra. She's the best person. She's the ideal person, I mean, to conclude a debate like this. So also on behalf of the other editors of the Comparative, thank you very much, Alessandra. You have 15 minutes, ready where you are.
So, can you hear me? I suppose you hear me. So first of all, I would like to thank Giuseppe Martinico and the Friends of Diritti Comparati for the invitation to participate to this highly interesting seminar, which is for me not an easy task, actually. I will inevitably touch upon some themes that have already been discussed. And as for the question about the relations between Italian and German legal scholarship, I will say something, but not all one could say about this subject. When Giuseppe told me about the initiative, I myself made a mental association to the debate on Italian theory in political philosophy and to the books of Esposito and Portinaro, who have taken opposing sides. Esposito defending such a theory and claiming that it is based on life history and politics and downplaying the role of the nation state, while Portinaro rejecting the theory and underlining instead the importance of the modern state and recovering the tradition of political realism. Now, in the presentation of the Routledge book series, Mariano and Marco explain, as they have explained live before, that its main feature is a methodological connection between law and politics. And they identify as the 2 main areas of interest the materiality of law and some classics, continental classics, unknown to an English public. I had the impression that this series cannot be encased in neither side of the Italian theory debate. It is more cross-cutting, their approach. So perhaps my impression is that there are single authors that are closer to Esposito's or Portinaro's view, but the project, I repeat, my impression at least, is that it's cross-cutting. Why is this series important in the legal and constitutional landscape today? I think we have to move from prevalent theories in the transnational Anglophone arena, which are legal and constitutional pluralism. Cesare Pinelli already recalled this, and there has been already a discussion on this point. I would also recall theories about global law and global constitutionalism, even if these are more contested. Anglophone currents of contemporary constitutional pluralism have been developed by authors such as McCormick and Walker. It has already been recalled, but many lawyers of other countries have developed specific variations of constitutional pluralism, starting from the Germans on Verfassungsverbund and multi-level constitutionalism, whose cultural roots are quite different from the British ones, even if they often converge on the practical level of the interpretation of legal cases. But the Anglophone environment has also hosted a project which is more skeptical of constitutional pluralism and even more so about global constitutionalism. It is the one developed by Martin Laglin, already recalled. Like other European constitutionalists such as Dieter Grimm, Laglin thinks that European constitutional pluralism downgrades key issues like authority, legitimacy, democracy, and the state. And so far as British authors are concerned, the critique is that they mainly follow a normative and constructivist approach, which in the end is also elitist. But Laglin's position are part of a broader effort to correct the idea that the common law origin of British constitutionalism and to reconnect it to the European continental tradition of state formation and constitutionalism. His project also implies a re-evaluation and, for an English audience, a real discovery of continental discourses about dynamic relations between state and society, political forces and constitutions, developed at the end of the 19th and at the beginning of the 20th century by authors, and many of them have been already mentioned, like Preuss, Gierke, Heller, Smen, Schmidt, Leibolds in Germany, Horiou, Duguy, Gurvich in France, Santi Romano, Mortati in Italy, to whom I would add also Antonio Gramsci for the reasons I will explain later. Now, this is why I was not surprised to see that the introductory essay to the English translation of Santi Romano was written by Laglin, and that this essay has become part of his book on political jurisprudence. Now, Santi Romano, Costantino Mortati, Antonio Gramsci, and also Emilio Betti are all authors that faced the crisis of the liberal state with the consequences that we know, the widening of the franchise and the entrance of workers' associations, political parties and trade unions into the political sphere, and the closer connection between the state and society. On the one hand, all of these authors share a critical view towards a positivist and normativist approach to the law. On the other hand, they have distinctive positions, as it has been said before. Santi Romano was an institutionalist and theorist of the plurality of legal orders, but he still worked within the coordinates of the modern state. It is true that since his inaugural lecture of 1909 in Pisa, he clearly understood that the state was exposed to a process of transformation, facing what he then called, I quote, the social movement. His institutionalism took these changes into account, underlying that the ordering of society expressed specific forms of juridicity and how these forms of juridicity conditioned state powers and regulated relations between different legal orders, as Mario underlines in his afterword. In this sense, Romano's idea of the institution may be seen as a further elaboration of the rule of law, and here I prefer to use the Italian expression Stato di diritto, since in English rule of law has a partially different meaning. I would also add that during fascism, Romano's work and practice tended to assimilate the Stato di diritto to the administrative state, keeping intact some of the legal guarantees and principles, but framing the common good above the real conflicts of society. Romano, in fact, didn't really focus on the deeper tensions between constitutionalism and democracy and on a specific role of political parties. But this, of course, doesn't diminish his interest for his work today, especially for a comparison between modern, contemporary legal pluralism and his institutional plurality of legal orders. The role and meaning of political parties is instead at the center of the work of Costantino Mortati. He is one of the authors that during fascism developed the notion of indirizzo politico, which, if I am not wrong, Marco has translated with political trajectory. Mortati's concept of material constitution was born in this context. Material constitution is not the opposite of formal constitution, but lies at its heart. It is identified by a condensation of political forces which delineates the fundamental political aims. At the time in which this notion was elaborated, the dominant forces were, in fact, the fascist party. And it was not easy for Mortati to adjust his theory to the democratic and pluralistic environment following World War II, since the idea of material constitution still presumes relationships of domination and subordination between social and political forces, so that some commentators have maintained that his concept cannot fully take account of difference, pluralism, and conflict. Anyway, with the new Republican Constitution, Mortati identified the material constitution with the multi-party system and with the values and principles enshrined in the Constitution. From a theoretical point of view, it is interesting to note that his theory has been influenced by Mosca's and Pareto's elitism, as well as by Weimar theorists such as Schmidt and Smend, while in the latter period, and especially in his comparative law works, the influence of historic materialism has also been more visible. And this is an interesting point since, as Marco notes in his writings, political economy is clearly part of the materiality of law. Now, in this context, Gramsci's position is also fascinating. Unlike the other figures, he openly opposed fascism and elaborated an original version of Marxist theory in which law and the state maintain a relative degree of autonomy, which of course does not mean that economy does not influence law and the state, but that the relations are more complex than a reductionist version of Marxism may suggest. The complexity of these relations is well conveyed by the concept of hegemony, which on the one hand refers to the political, ideological, cultural realms, but on the other hand is connected to the economic base of production. His idea of hegemony includes both the moment of direction towards certain ends and the key role of conflict between classes and social groups. The main subjective political force is also for Gramsci the political party, which following Machiavelli he called the new prince. Gramsci has had a complex understanding of the law, on the one hand instrumental to reach the ends pursued by hegemonic groups or by groups who aspire to become hegemon, but on the other hand he had also a reflective idea of the law linked to custom and even to a kind of natural law rooted in popular culture. As is well known, Gramsci's reception in the world has been huge, albeit sometimes distorted. I will only briefly address two issues. First, there is a significant debate on the question whether Gramsci has pointed at a new kind of cosmopolitanism beyond the state, or whether his main framework for political action is the nation state. There are passages in his notebooks which justify both positions. But for reasons which I cannot fully explore here, I believe the second position is more correct, while it must be also an effort to reconnect the national to the international level. Second, we have to keep in mind that Gramsci influenced the field of international relations, where some authors, underplaying the role of the state, have transferred the concept of hegemony to the transnational sphere, speaking of the hegemony of global capitalism, uniting multinational corporations, state powers, and international economic institutions. These interpretations have inspired, at the beginning of the century, Mattei's work on imperial law, who, developing further Sacco's notion of prestige, considered US law as an instrument and reflex of global hegemony, but also tried to identify some alternatives and sites of resistance. I cannot go into details here, but I think that the debate that was originated by this theory could be better appreciated if one looked not only at the instrumental function of the law, but also at its expressive, symbolic, and constitutive functions. In the few minutes I have left, I would like to make some remarks on the importance of the translation of Betti's hermeneutics. Lars has made an interesting point outlining Betti's critical distance from Gadamer with regard to the hermeneutic circle and the Vorgriff der Vollkommenheit, since Betti would have resisted an all-embracing claim of authority of tradition and left more space for disagreement and eventually emancipation. This focus on hermeneutics, traditions, and spaces of disagreement is highly interesting, I believe, also for a comparative constitutional lawyer, since it helps to better investigate a concept which plays a key role from a methodological point of view, that of constitutional culture. I personally have reached this perspective moving from Heberle's studies on Verfassungskultur in Germany and from my master's in Rome, especially Paolo Ridola, who has a pronounced historical sensitivity. But a parallel trend has also grown in the Anglophone sphere, thanks to the works of Paul Kahn and of some constitutional lawyers in Yale, including Ackerman. Both trends, the European and the US, have been clearly influenced by hermeneutics and anthropology. My very, very last point regards classics that have not been translated yet, or that have been translated only in little part. I am thinking through those Italian lawyers who have developed the notion of esperienza giuridica, which we could translate with juridical experience, Capograssi, Orestano, and Giuliani. The issue was already raised some years ago by Gianluca Bascherini in a comment to Esposito's book, while other Italian constitutional scholars, Giorgio Repetto himself, but also Francesco Cerrone and Silvia Nicolai, have written in English drawing on Giuliani's thought. I cannot elaborate more on this, but I was positively struck by Luglin's emphasis on the notions of experience and Erlebnis. Here again, we have to be aware of the differences among constitutional cultures and also among Italian authors themselves. For example, Orestano follows a more historical approach. Capograssi has a more philosophical and metaphysical take, also approaching the problem of the state. Giuliani reconnects to the classical and medieval tradition of logic and community, but they all share a deep belief in the relation between law and ethics and in a conception of law which is not instrumental, but constitutive and derived from the relational experiences of real individuals in their communities. Thank you.
Thank you, Alessandra. Wow, I mean, this was really fantastic and rich. This was the best manner to conclude this webinar. And let me say a couple of things before closing this event. First of all, this event has been possible thanks to the help given by Marco Bassini and Claudio Di Maio. So thanks indeed, guys. And thanks, of course, to the other directors of Diritto Comparati. And the very final thing before thanking our speakers is just a gentle reminder about another joint event that Diritto Comparati is organizing on Monday with the president of the European Court of Human Rights, Robert Spano. We are going to have a webinar with him. He's going to present his latest paper that published in the European Law Journal. There will be then a round of comments given by Raffaele Sabato from the European Court of Human Rights, Cristina Covalli from the General Court, and Advocate General Giovanni Pitruzzella. And this is another important joint event, this time co-organized with EU Law Live. So thanks to Oreste Pollicino and to Daniel Sarmiento. They are really the let's say mastermind behind this. So having said that, I want to thank again our speakers for this very rich debates. Thank you very much. I learned a lot, and they said hopefully this will be just the first event of a long series of meetings like this. Thanks indeed. See you soon. Bye-bye.